welcome everyone. This is the 7th session of the July 2023 Ibis Prep Florida Bar Crash Course. And this week we're doing con law. Before the recording, we played Jeopardy. It was super fun. I think everybody was a winner. So let's go right into the material today and do our best. Like I said, this is going to be a 2-part series. We're going to go back to the material on Wednesday, and then we'll look over some essays on Saturday. So this is the materials folder. Everyone should have access to it and kind of know the vibe by now. We did an essay workshop last year, so I put it in here so you can kind of look at how that workshop went. There's 2 outlines because there's the outline that's complete, and then I stuck in the MBE outline because they can test federal law on these essays. So you do need to know federal law as well. So, there's a couple outlines to look at. We have the Florida specific rules. Then we have our questionnaires always for con law. I also am going to teach Crim Pro on Wednesday, just as it's tested via essays, 4th, 5th, and 6th Amendment. They also test Crim Pro and multiple choice, which I'll teach down the line, but they have recently, there's been a trend towards testing 4th, 5th, and 6th Amendment in terms of like unreasonable search and seizure or improper or lack of probable cause, or they needed a warrant or exigent circumstances. That whole conversation, 4th, 5th, and 6th Amendment, has more heavily in recent years than anything else. Not than anything else, but it's been a trend that I've noticed. So I could foresee it being tested again, even though it was just tested February 2023. So I include the Crim Pro questionnaire and the answers in here. These are student responses. I think they're solid. We might go over them if we have time on Wednesday. We have the Jeopardy that we just did, and then we have different model essays, which, as you know, tease out the applicable rules of law. Some are federal and some are Florida. We'll get to the PowerPoint real quickly, but I do think it's instructive to start backwards. Like we'll do the maze backwards, just so you kind of get an understanding of what kinds of things are heavily tested on Florida or federal con law essays. You see standing, injury, redressability, cause and fact, right? Or injury and fact, causation, and redressability. Those are the things that you pretty much start every essay off with. Sovereign immunity. So we talked about that being the 11th Amendment could potentially be tested. That's why I want everyone to know all the amendments. Home rule powers. So chartered counties in Florida have the authority to enact ordinances to regulate, like Dade County. That power is known as the home rule power. Public speech, First Amendment. We talked about strict scrutiny for content-based, or if it's time, place, and manner. It's more of a intermediate scrutiny. It would be if it's conduct-based and regulated time, place, and manner, a different test is used, right? Like a more of an intermediate test. For conduct regulation of speech in a public forum, even different test. The law must be content neutral, both viewpoint and subject matter neutral, narrowly tailored, and leave open alternative channels of communication. For non-public and designated forum, the test is even less strict. The law merely must be viewpoint neutral and be rationally related to a legitimate government interest. See, they go really deep into the time, place, and manner one on this essay. So it could be a good First Amendment essay. Unprotected speech, like likely to incite imminent lawless activity, or defamation, or misleading commercial speech, or obscenity. These are types of unprotected speech, or gag orders are usually disfavored. Vagueness and overbreadth. I'll say this is something that probably comes up on every con law essay. You can argue that the law is vague or overbroad because the essay is likely going to give you a law, an ordinance, a policy, and have you attack it. Why is it unconstitutional? A great way to attack any law or ordinance is that it's vague or overbroad. Vagueness meaning I don't know what's being punished. Loitering. What does loitering mean? Right? You're going to punish me for standing outside? Like I was just standing. Loitering is usually vague. It usually has to say specifics. Overbreadth. Overbroad means it's punished. Sorry. It's punishing legal activity as well as illegal activity. Like it's aimed to stop a certain type of speech, let's say, but it's also punishing speech that we don't want it to punish. my example, and this would never happen, but there's a ban on 4-letter words, right? Obviously know what words they're intended to ban, but that would also ban duck, pool, pond, right? These other 4-letter words that shouldn't be banned. That would be overbroad, it oversteps. Procedural due process. So see, I told you, Kluger, it comes straight from Florida essays. I told you, if you're watching this recording, you didn't play Jeopardy with us. But when we played Jeopardy, the answer was the Kluger doctrine. I said I wouldn't teach this if it wasn't tested. I've seen it on multiple essays. So we'll talk about that. Procedural due process and substantive due process. Hey, Omar, if you have questions, we'll talk about it. But so procedural due process and substantive due process. Procedural due process means notice and hearing. Substantive due process means your life, liberty, property has been deprived. So substantive due process is often confused with equal protection because it's kind of the same concept. But remember, substantive due process applies to everyone. Equal protection applies to a specific group of people. If there's a law that says, let's just think over COVID, everyone has to wear a mask. You could argue that that's a substantive due process. It's depriving you of some fundamental liberty right, like that's substantive due process. We're all being deprived here. Now, if they made the law, all men have to wear masks, that would be an equal protection issue because it's aimed at a specific class. Did wearing masks actually present equal protection or substantive due process issues? No, apparently we all wear masks. I'm just saying, if you were writing a bar essay, you could argue that. That's all I'm saying. Okay, so equal protection, when it's a suspect class, strict scrutiny is applied. So we see equal protections tested a lot. Oh, the Kluger doctrine, right? So fundamental rights, you apply strict scrutiny. The Kluger doctrine says that access to courts can in fact be restricted so long as there's a compelling public necessity and there's no reasonable alternative. Just like I said in the Jeopardy game, probably during the coronavirus, they could have limited access to courts because, it was a public necessity for health. That would be under the Kluger doctrine. Equal protection, we know different scrutiny levels. RAND, race, alienage, national origin, and disability in Florida. Intermediate scrutiny is gender, illegitimacy. And then rational basis is going to be everything else, wealth, age, anything. And then striking of unconstitutional parts of ordinances. If parts of the ordinance is found unconstitutional, the court may be able to strike that portion, save the rest, provided the ordinance has a So this is just a example of a 2018 con law essay. And you see it was mostly federal, it was mostly First Amendment issues. Fourth Amendment, 14th Amendment. That's a great example of what a con law.
The captain has requested that everyone, including the flight attendants, remain seated, but their seatbelt fastened for the remainder of the flight.
That was awesome. One of our students is on a plane because we're recording a movie called Bar Prep on a Plane, starring Tom Hanks. Okay, let's look at this one a little bit. So, and I'm just going to gloss over these before I get into the PowerPoint. But Florida law provides that no one shall be deprived of life, liberty, and property without due process of the law. The requirements track the federal constitution. That's what I was saying. Florida explicitly adopts the federal constitution. We have a heightened right of privacy. Florida does allow recovery when the government places an inordinate burden on property. So this is about property. It's about sex offenders. They're probably going to be subject to rational basis. Now, here's a key point that you would only really get from a practice essay. Sex offenders can validly be required to register with a sex offender registry, and a sex offender conviction is a matter of public record. So that's just something that you might not have known. They can be required to register with a sex offender registry. I think that's Megan's law. The right to liberty is a fundamental right, or laws or ordinances that infringe upon this right are subject to strict scrutiny. Under strict scrutiny, the burden is on the government to establish the ordinance necessary to serve a compelling government interest. The government must establish that the ordinance is the least restrictive means of accomplishing its objective under the circumstances. The Florida Constitution prohibits setting excessive bail. In fact, everyone jailed for an offense other than a capital or life felony has a right to a pretrial release so long as they do not pose the risk of a flight risk or failing to show up to the court date. They do not pose risk to the judicial power of the community at large. Ex post facto, see, these things can come up. Ex post facto, bill of attainder, and contracts clause. They really have their way with con law questions. So an ex post facto law means we can't retroactively punish non-punishable behavior. You know, if they say it's a crime to teach the bar on Zoom, well, they made the law in a week, they can't punish me for doing it today. That's ex post facto. Bill of attainder is, I think of like Looney Tunes, you know, where someone just does a crime like Wile E. Coyote and they just throw them in jail. They don't give them a judicial process. It's like they do something and the next scene they're just like locked up. That's bill of attainder. It's depriving someone of a trial. And then a contracts clause, impairment of contracts clause, and I have seen this tested on Florida essays, is they can't make laws that impair contracts, whether public or private. So a curfew law is a great example of an impairment of contracts law, because if they say no one is allowed out past midnight in Miami, you're impairing a lot of contracts. A lot of businesses operate past midnight, so it would be an argument for the impairment of contracts. Definitely, you want to know how to enact laws and pass bills in Florida. To be properly enacted, legislation must contain a short, simple statement of its purpose, contain only one subject matter, heavily tested, single subject matter, must contain a description of the law that is easy to understand, and must contain enacting language indicated as enacted by the Florida legislator or the authority of the state of Florida. Usually it says being enacted in the state of Florida, la-di-da-di-da, right? Similar requirements may be applied to the Board of Commissioners or ordinances. Government entanglement. So this would be encroachment, separation of powers, key concept. The Florida Constitution provides similar protections as the federal Constitution does in this regard. An ordinance will be examined to determine whether it's directed towards religion and that, okay, so they're talking about entanglement in terms of the Lemon test. I was talking about entanglement in terms of encroachment, but same concept. Again, the Lemon test is under attack right now, just like abortion laws in the Supreme Court. And I don't mean that in a political way, you know, who am I to decide? But it's just, it's not clear whether the Lemon law still prevails, but you could still know what it means. It just means a general separation of church and state. There's not going to be excessive entanglement. There's going to be a secular purpose, and there's going to be no. Does anyone know the other? Can anyone help me here? See, I don't remember the Lemon law anymore. That's how it's 2 years ago. There can't be excessive entanglement. There has to be a secular purpose, and it can't be neither advance nor inhibit a particular religion. See, Lemon law is already leaving my mind. That's kind of how con law goes. Something that you learned could be out the door the next day. But there can't be there has to be a separation of church and state. This thing right here, they're not going to test anymore because they used to say you couldn't pray in school. Now you can pray during football games, so they would not test that. Double jeopardy. Florida Constitution prohibits punishment twice for the same offense, right? That's Fifth Amendment. Vagueness, again, you see it comes up very often. An ordinance must specify the harm it protects from or provide requirements and tailor the ordinance towards that objective. If the ordinance is overly vague, it is unconstitutional because it will punish just as much lawful behavior as it will unlawful behavior. Separation of powers, that's what I was talking about earlier. There's a requirement that each body of government, legislative, executive, and judiciary, must have separate powers that may not be infringed upon by other bodies. So we can call that encroachment, separation of powers, law against entanglement of the branches. Commissioners may not establish crimes. Crimes may only be declared by the state legislator. Municipalities may legislate that certain things be considered ordinance violations, but may not be punished. So essay is very difficult. They're just going to give you a statute and say, you know, this is the mayor can punish these people, and then it'll just be one sentence, and you just have to recognize, wait, the mayor can't do that. Encroachment, entanglement, separation of powers is going to be a concept there. So Florida does not permit someone who's a convicted felon to serve in government office. To be eligible for government office, an individual must not have been convicted of a felony, must be at least 18 years old, must be a resident of Florida, and must not be incompetent. Okay, I'm in a class right now and they do this, group discussion. What do you guys think? Is this fair? Do we think it's fair that if you've been convicted of a felony, you cannot be serve in office? You can put it in the chat. I'm just interested. Do we agree with that law?
Andrew, it's Pablo. I don't know if I agree 100% with it. I think it would depend mainly on the felony itself. Like if you have a felony for like financial crime, then you wouldn't want to be in a government position.
Exactly. I tend to believe that people change. I know Barbara probably believes that too. But again, like I said, just because you don't agree with the law, it doesn't mean that it isn't the law. And Barbara's saying she loves this, and Omar's saying we have criminals in Congress right now. No comment. All right, let's look into the slideshow, and it might take me a second to get it loaded, but I think I figured out the process. If you hear my dog whimpering in the background, do my best to train him. I'm sorry. I spoiled him. Well, he was spoiled, and now there's no recovery. Rosie's good. You never hear her. Okay, so, rap albums. I'll talk more about this next week, but let me just show you some examples of what this looks like. I hope everyone can see. So you can see this, right? This is me. This is rap album of the year. Ill-Gotten Gains. That was my name. And my album was Restitution, right? It reinforces a contract thing, restitution, ill-gotten gains. I think that's, cool or whatever. So this was my student who scored a 156 on the Florida bar, and he was very much a participant in class, Participation is the key. Risk of Loss by ECE. I don't really understand why the name, but I'm not voting here. Risk of Loss for Equitable Conversion. And I think the E was just like easy E, like a play on that. But, risk of loss, if you have a property and you buy it and the contract is in a month, the risk of loss will pass to the buyer on the date of the contract. That's called equitable conversion. And I think this is Joel's picture from when he was a kid. So there's that one. Just two more and then we'll get started. But my point is I want everyone to create their own, and it'll be fun. And fun is something you don't really find in bar prep. So let's see this one. I think high favorite, heavy favorite, and we all love Sam Collier. She passed the test on her 5th attempt with 5 kids working full-time, and she came out with the Attractive Nuisance, Broken Trampoline. So that was her name, Attractive Nuisance, and the album Broken Trampoline. We all know that concept from Torts. Pretty entertaining. And then last but certainly not least, a student who I think is a model student. I have an interview with her on YouTube about how she passed both sections, and she did very well. It was just like not someone who passed by the skin of their teeth, someone who just passed with great scores, and it was because she did all the things that she needed to do. And her album is called Strictly Scrutinized. We can see this. Sus Class. I think that's like the punk rock name, Sus Class, and Strictly Scrutinized. And what a transition into con law, right? Because it's talking about suspect classes and when there's strict scrutiny versus intermediate scrutiny versus rational basis. So hopefully everyone got some good ideas. I love how you're asking if Biscuit is a puppy. No, he's 10 years old. He's just a spoiled little brat. So I'm gonna go ahead and start this PowerPoint, and we'll get after it. But we'll talk more about those rap albums, and hopefully there's some creative ideas. So let's start the presentation. We're going to do rap albums, Jeopardy we played, Florida and federal con law review. And remember, I said it's going to be a 2-part review. We know the Heat are playing, so we're not too worried. You know everything about me. I always say I want to rewrite the Constitution because, like I say, it was written 300 years ago. It was written at a time where certain members of society counted as 3/5 of a vote. Women didn't count at all. I just don't think it was really written to contemplate the issues of today. But maybe I'm naive and the Constitution is awesome. So, we're still working mindfulness. If you're here on Memorial Day, you're doing the right things, but also make sure there is a balance in your life. I can't stress that enough. Stress, get it? So try to be mindful. Study strategy, 2 different exams. Con law is tested so often, as I'll show right here, right? It's tested Florida Con Law, Crim Pro, Ethics. Crim Law, Crim Pro, Florida Fed Con Law, like it's tested every single year except maybe 1 year. So there's almost 100% chance, maybe like a 98%, 95% chance you're going to encounter con law in the Florida bar. We can see the screen and you can hear this. Can you see this or no? No, wait, hold up. I think you can see it now. I watched this video before class to make sure it was valuable. Don't worry. I wouldn't waste your time.
How should I start a federal law bar exam essay?
You should always start with standing. And the key elements of standing are injury in fact, causation, and redressability.
Can you explain the difference between substantive due process and equal protection?
Sure, substantive due process is when there's been a deprivation of everyone's rights, whereas equal protection is when there's been discrimination against a particular group.
What is the Commerce Clause?
So under the Commerce Clause, Congress can regulate the channels, instrumentalities, and economic activities that in aggregate have an effect on interstate commerce. Hey, Shelby, do you know what's required when there's a governmental takings?
Just compensation?
Her. Right, so that's a little, I have some videos all over the internet, not all over, but things that might be helpful. And that was just a kind of a point. You do want to start your essay off with standing. You definitely want to make sure you know the differences between equal protection and substantive due process. And then, yeah, takings require just compensation. So that was just some, things to start and get our minds racing. Now let's talk about the approaches to Florida and federal con law. And this is a part where I'm really going to show you there's two lenses, and we'll really go into this next week in detail. But when you get a con law essay, there's two lenses of attack. There's the federal Constitution, which starts off with the amendments. First Amendment, freedom of speech, freedom of religion, freedom of the press, freedom of assembly, freedom of petition. Fourth Amendment, Fifth Amendment, Sixth Amendment, which are those crim pro amendments. They're not going to be tested when it's attacking an ordinance, but you definitely need to know them, and we'll talk about them. But it probably would be 14th Amendment, which would be due process applied to the states or equal protection. So, you're going to look at the First Amendment and all the fundamental rights, the freedom of speech, freedom of religion. You're going to look at the 14th Amendment, equal protection. You're going to consider due process issues, procedural and substantive due process, right? Those are, that's the federal approach. And we'll talk more about that on the next slide. But then besides just the federal approach of the Constitution and federal implications, there's also a Florida lens. Florida has its own constitution. Florida has expressly adopted the federal constitution, so you need to know all those federal issues. But then Florida has its own subset of laws that also comprises Florida con law. So we talk about the Sunshine Law. That's something that's very heavily tested. The Sunshine Law is a right of access, that all governmental proceedings need to be open to the public. We need access to the minutes, the conversations, the meetings, everything. That's the Sunshine Law. Homestead exemption is a right to protect your property, half an acre inside a municipality, 160 acres outside a municipality. The homestead exemption protects you from all creditors. And just to ask, does anyone know who can pierce the homestead exemption? Which creditors can pierce it?
Will be the mortgager, taxes and liens, and mechanical liens.
Exactly. Or I would say Uncle Sam, the government, right? Any government judgments. So government judgments or judgments on the house itself, like mechanics liens or construction liens or mortgages. Cool. So that's the homestead exemption. There's also a tax implication of the homestead exemption in Florida, which means you get a 50% deduction off the taxable value of your home. If your home is assessed at $500,000, you can deduct $25,000 for ad valorem taxes, property taxes, and $25,000 for school board taxes. I think you might even be able to deduct another 25 now. It's 75,000, but it's not heavily tested. Just know that there's a tax deduction from the homestead exemption, and there's, more importantly, the creditor protection. So they can't take your house. This comes in a lot with One, when we do wills on multiple choice, because there's homestead implications of intestacy. And then also with real property, when, you know, someone's trying to convey someone else's homestead, that might be a problem. General versus special versus general laws of local application. So a general law is a law that applies to everyone in the state. A special law is a law that applies to Dade County or Duval County specifically, and it requires a referendum, a vote. A general law of local application is when it's based on population. And as I explained to the class, it's usually to get around the vote. There's no referendum. So if they say this applies to counties with over 1 million people, it probably only applies to Dade County, maybe Duval County, maybe Pinellas County. I don't know, but it would be a way of getting around it. That's a general law of local application. Chartered versus unchartered counties. Chartered counties like Dade County have this power called the home rule power to enact ordinances that do not conflict with the Florida or federal constitution. Enacting a law or ordinance in Florida will look specifically on how to do this. There's a lot of specificities about having a clear title, having an enactment clause, having a single subject, being related to the health, welfare, and morals of the people. These are different contemplations that we'll look at for enacting a law or ordinance in Florida. Again, remember, I'm going to go over the outlines and stuff in detail next on Wednesday. This is just to understand what things you really need to be confident in. Powers vested to several separate branches of government. I call that encroachment. I might call that separation of powers. I might call that a rule against entanglement, right? Judicial powers, executive powers, legislative powers. Vagueness and overbreath, I think, comes on almost every essay. This law is vague. It's like loitering. What is being punished? It's not clear. This law is overbroad. It's punishing too much. It's punishing legal activity as well as illegal activity. Like, you can't say 4-letter words. Well, now I can't say the word door, but I can say the, you know what I mean? That's overbroad. And then the Kluger doctrine, I just have seen a test in like 2 or 3 essays. The Kluger doctrine is an exception to fundamental rights, such as access to courts, that in compelling times, if there's a compelling need, you can override that restriction. I was given an example of during the pandemic, maybe they could restrict access to courts because it's in our public health. So that's the Florida approach. I mean, there's other things to consider, certainly. You know, I talked about general GO bonds versus REV bonds. GO bonds, general obligation bonds, are like bonds that build a school or a park. They're supported by taxes and need a vote, versus REV bonds, revenue bonds. They're the revenue of the actual project will pay back the bondholder. So it would be like a toll bridge or a airport, and that is not going to require a vote. But we'll get into details, and that's not a major detail. Major details, I did it in order, honestly. Sunshine law, homestead exemption are super heavily tested. Enacting law or ordinance in Florida and the single subject rule is heavily tested. There's also something we'll talk about in a minute called special legislative session, where the governor could call a special session. And just remember, unless they have 2/3 vote from both house, whatever they call the special session for is what they actually have to speak about during that session. So that's a good introduction to the Florida lens. Let's take a few minutes to talk about the federal approach. So 1, standing, injury, causation, redressability. Do they have standing? Is there state action, right? If it's just private actors, they might not have standing. Justiciability. I sound like Kevin Garnett when he tried to say this word on Wheel of Fortune. I forgot what it was. Couldn't pronounce it. But justiciability, ripeness, and moot. Oh, it's equivalent. You got to see Kevin Garnett saying equivalent. So justiciability, ripeness, and not moot. Ripe, it's too early. Moot, it's too late. Due process through the 14th. So, you know, the 5th through the 14th, substantive procedural. Substantive is everyone's rights, life, liberty, and property are being impacted. Procedural is mostly notice and hearing. First Amendment, religion, freedom of speech, etc. Religion is free exercise and establishment clause. Scrutiny levels, we talked about strict, intermediate, rational basis. You definitely need to know the definitions cold. I think we'll go over that. If not today, then on Wednesday. 5th Amendment, takings, due process, self-incrimination, Miranda, double jeopardy. 14th Amendment, equal protection, suspect classes, race, alienage, national origin, and disability. Also know that right to vote, right to travel, these are things that are fundamental rights. We have a heightened right of privacy in Florida. Like, all these little things, these jewels I'm dropping are just like points you can get on your essay. So I hope everyone at least is listening, and then we'll make sure to truly understand these when we go in further detail on Wednesday. The Commerce Clause, the Dormant Commerce Clause, privileges and immunities, right? These are some considerations. The Commerce Clause, the federal government can regulate the channels, instrumentalities, and economic activities that in an aggregate have a substantial effect on interstate commerce, just like I said in that TikTok video with Shelby. The Dormant Commerce Clause is states can't enact legislation that'll unduly burden interstate commerce, right? I was thinking about the tire example. The state of Georgia can't say you have to have tires of a certain size, because then if I'm driving from Florida to South Carolina to get my fireworks, you know, it would be annoying. I'd have to change my tires when I go through Georgia. They can't do that. Privilege and immunities, they can't discriminate against out-of-staters. Classic example is fishing, right? You can charge more for out-of-staters for a residential fishing license, but you can't charge more for out-of-staters for a commercial fishing license. That would be discriminating against out-of-staters, charging more for a commercial license. Commandeering clause, encroachment, state sovereignty, and sovereign immunity. I mentioned all these things because all these things have been tested. Nothing I mentioned on either one of these, this slide or this slide, hasn't been tested. Commandeering clause, the state can't force the, the federal government can't force the state to enact legislation, but they can induce them. They can't compel them, right? They can say, hey, we're not gonna give you any funding for your highways if you don't raise your drinking age to 21. Actually, a buddy of mine, everyone's an acquaintance of mine, owns a smoke shop, and he says he's getting killed right now because Florida raised the tobacco age to 21, right? But that was a state thing. The federal government couldn't force the state to do it, but they could say, if you don't raise the tobacco age to 21, we'll restrict your funding. That's fair. Encroachment, we talked about. Legislative, they make the laws. Judiciary, they are the judges, and then the executive branch is, he's the leader. He's the one who carries out the laws. And then they can't encroach on each other. So if it says, this gives the mayor the power to make judicial decisions, that would be an encroachment issue. State sovereignty. So what's not, reserved to the federal government, we talk about preemption or federalism, will be reserved to the states. And then sovereign immunity. An individual can't sue the state unless the state consents, or it's like a state actor in their individual capacity. Like that's what it usually ends up being. They don't sue the state, they sue, maybe the attorney general or something like that. So I also talked about how we're going to talk about crim pro and crim law in this week, because to me, it's tested on essays. There's a rising trend for it to be tested, and it is a constitutional conversation. Fourth Amendment, we have reasonable expectation of privacy, probable cause, warrants, stop and frisk, right? That's Fourth Amendment. We'll talk about this more on Wednesday, but just exposure. Fifth Amendment, right to counsel under Miranda, also due process, also takings, also double jeopardy, also right against self-incrimination, like the Dave Chappelle skit. Sixth Amendment, your right to counsel after adverse proceedings begin, right? Remember, Fifth Amendment, when you get your Miranda rights, that's when you're in custody. Sixth Amendment, your right to counsel is after they've filed charges. And then also speedy trial. And then, some things that they do test, and we'll talk briefly about this. Murder, it's when you kill someone. Arson, when you burn something down. Conspiracy, when you conspire to conspire. No, conspiracy is the, agreement to commit a crime with someone. And then inchoate crimes, they merge into conspiracy. Attempt and solicitation, and then the theft crimes like larceny, etc. I put this guy's website here. Yeah, we can see it. This is, oh shoot, let me show you. I am not someone who I don't think there's a lot of people out there doing great education. That's kind of like my ikigai in life. But this person, Hornsby, is my guy. I've always relied on him when it comes to crimes. It's called Hornsby Law, like hornsby.com. He does all the Florida crimes. I would just, as a matter of course, for preparing for this test, just go through all these crimes and just make sure you're familiar with them. Florida crimes aren't heavily tested, I would say, but the more you know, right? That's kind of the main thing about this. The more you know, it helps, and it is tested. So it can only help. So, this isn't a criminal law lecture, but it is important to know. So just a couple things I'll end class with, take about 10 more minutes and call it a night. Root for the heat. I'll read some important statements to you. So what is the purpose of the law? The Florida Sunshine Law is a series of laws designed to guarantee that the public has access to the public records of governmental bodies in Florida. Under the Sunshine Laws, all meetings at which public officials discuss public business must be noticed and open to the public. Records of such meetings must also be accessible to the public. The public has a right to government information under the Florida Constitution. There's an exception to the Sunshine Law meeting requirements for unplanned meetings between state legislators. This exception applies to meetings between two state legislators or one state legislator and the governor. So look for a party, a bunch of legislators are at a party. If they just, hey, Tommy, what's up? Nothing. Oh, that's unplanned. But they say, hey, Tommy, let's go over to the bar and talk about this law. That's a planned meeting. That's going to be a violation of the Sunshine Law. So look out for that. Homestead exemption we talked about. Florida provides protection from creditors foreclosing or otherwise taking possession or title of an individual's real property when such property is owned by a natural person, serves as the primary residence of the owner or dependent of the owner, i.e. the spouse or the minor child. The primary residence, the owner has the intent to use a property as his or her principal residence, and the owner and or dependent of the owner resides at the property. It protects up to a half an acre of contiguous land inside a municipality or up to 160 acres of contiguous land outside a municipality. This includes any improvements to the land, including homes built on the land, etc. Homestead exemption heavily tested. Those two things they test so much. Why? So people from Utah can't pass this test, right? That's how they make Florida hard. To be fair, February 2023 was like the first time where it was a very federal test, but usually it's a very Florida test. So I'm just giving you my knowledge from my experience. It's usually a very Florida test, but February 2023 was almost all federal law. But this is a Florida specific law. Another Florida specific law, as I talked about, important is enactment of a law and passing a bill in Florida. To enact a new law in Florida, you must have adequate title such that a reader could reasonably understand what the law contains. An enactment clause, be an enacted that, reasonably related to the health, safety, morals, and welfare, not vague or overbroad and single subject. Passing a bill in Florida, remember I'm just a bill up on Capitol Hill, read 3 times into the legislator, passes both houses in identical form, we call that bicameralism, title, single subject, and the governor's signature. In the federal government, they can do a pocket veto. In Florida, there's no such thing as a pocket veto. So we talked about general laws, special laws. General laws of local application, just so you hear the definitions precisely. A general law is enacted by the Florida legislator and applies uniformly statewide. Special laws enacted by the Florida legislator and applied to a specific part of the state. Need either one of the following requirements. Notice to population of the part of the state being affected by the special law, or approved by a referendum vote of the majority of electors in the part of the state being affected by a special law. General law of local application, like I said, population is the biggest thing. Enacted by the Florida legislator and applying a specific region of the state, often applying based on size of population. All kinds in Florida with a population of over 300,000 residents. Again, on Saturday, we'll go through a lot of essays. One of the essays I assigned is the essay that I took my year, February 2017, and it was brutal, but it wasn't even as hard as the real property essay they gave that year. So I'm just letting you know these essays are not easy, and I just gave you a true essay that I took. I'll probably give you the real property I took too. I took as well. All right, additional Florida common law issues. Access to courts. Everyone has the right to access the courts regardless of the injury without sale, delay, or denial. This right can be abridged under the Kluger doctrine if there's a necessary and compelling public interest. Any changes to the Florida Constitution must be approved by the vote of 60% of the people voting in the matter. And then, like I said about special sessions, the governor, by proclamation stating the purpose, may convene the legislature in special session during which only such legislative business may be transacted as within the purview of the proclamation, meaning why they called the special session, or of a communication from the governor, or is introduced by consent of 2/3 of the membership of each house. So if it's not going to be the reason the governor called the special session, then they have to have a 2/3 vote from each house. Fundamental rights, strict scrutiny. When a fundamental right is implicated, strict scrutiny applies. Under strict scrutiny, the government must show that the law is necessary to further a compelling state interest. For all other rights, only rational basis review is required, under which the plaintiff must show that the law is not rationally related to any legitimate government interest. Legitimate government interests under the state's general police powers include providing for the health, safety, welfare, and morals of the people. Beautiful. Takings. Pursuant to the powers of eminent domain, the state and local government may take, appropriate, or physically invade private property for a justifiable public purpose with just compensation due and owing to the owner of that property. Eminent domain also covers the takings of personal property. All right, and I'm gonna end this with a great question for the audience. Does anyone know who this man is? The second president of the United States. Yes, John Adams. Excellent. It's just my point showing that people don't really know too much about American history and the Constitution. But yeah, I hope you enjoyed today's lecture. I know it was a lot, and we didn't go into super details, but that's why we have Wednesday's lecture to go into super details, and then Saturday's workshop to go over essays. I can't tell you how important this week is because it's federal con law, it's Florida con law, and I do want you to start looking at 4th, 5th, and 6th amendments so you can be prepared for that. The class is going to start moving quick, right? I think next weekend is real property, and then it kind of just scatters into, you know, multiple choice subjects and some of the other essay subjects. But we have this week to do con law, next week to do real property, and yeah, it's moving along swimmingly. I updated the calendars for Florida MBE and for the UBE, so make sure you are referring to the new calendar, and if you printed the old one out, print the new one out. I really appreciate everyone for being here on Memorial Day. Hopefully the Heat get the dub tonight, but like we said at the beginning of class, it's just a game. No matter what, we got to wake up and study tomorrow.